Strategic Considerations and Judicial Interpretations. The session will be moderated by Kunal Vyas. The panelists include Mihir Thakore, Ritin, Rashna Mistry, Jatin Jalundhwala, and Honorable Justice Ravindra Bhat. I request the speakers to kindly come on stage. Thank you.
Very good morning to one and all present here. I am Kunal Vyas, partner at Gandhi Law Associates. We are privileged to be hosting this session today at MCIA. I want to thank Madhukeshwar, Neeti, everyone at MCIA for giving us this opportunity. The topic for today's discussion is Section 29A, Time Limits, Strategic Considerations and Judicial Interpretation. For an effective dialogue on such a critical issue, we have a distinguished panel comprising Justice S. Ravindra Bhat, former Judge, Supreme Court of India, Mr. Mihir Thakore, Senior Advocate, Mr. Ritin, Senior Advocate, Mr. Jatin Jalundhwala, Joint President, Legal and Company Secretary at Adani Group, and Ms. Rashna Mistry, General Counsel at Tata Projects. The panel is diverse and will throw light on several issues concerning 29A from different perspectives. As we all know, Section 29A was inserted in the year 2015, which is about 20 years of the operation of the 1996 Act. And this was required because the arbitrations under the 96 regime were unending. The legislature thought it fit to amend the law and introduce a provision which mandates the tribunal to act in a time-bound manner. Despite these amendments, the 2015 and 2019 amendments, there are several issues concerning 29A which are still boiling. Before I go to the panel with several questions, I want to invite on stage Mr. Prashant Narang from Trust Bridge Rule of Law Foundation to share with us his findings on the effect of 29A. Mr. Narang, please.
Thank you, Kunal. I'll be very brief and take you through the findings. So as we know that Section 29A was a bold experiment. It's very unique in nature because it's a statutory clock to end the culture of delay, and nowhere else in the world we have such a provision. Many scholars warn that this is a uniform, one-size-fits-all deadline. It could undermine party autonomy, deter good arbitrators, or even push complex disputes back to already clocked courts. The question is, were they right? And we look at Delhi High Court's data and look for answers. So we look at 10 years data from 2015 to 2024. We find 202 reported cases under Section 29A. What do we find? We find that 98% of extensions were granted. Refusals, only 4, and that too on technical grounds. Sanctions, because 29A proposes, it offers certain sanctions, for example, fee cuts, cost imposition, etc. So sanctions almost disappeared. Fee reduction in 0 cases. Substitution of arbitrators in just 2% cases. And adverse cost on parties in less than 3% cases. And yes, the process was fast. Median time taken was just 3 days, with 60% of cases finished in a single hearing. And when we look at the orders, these were consent orders passed. So even repeat extensions. So there were cases, that came to the court for second time, third time, fifth time, and 7th time as well. And there were 15% of cases which were multiple extension requests. They were also granted almost automatically, often in a single day, in a single hearing. So at first glance, this speed looks like success, but in truth, it's failure. And why do I say that? Because Parliament's intent was not simply to process papers quickly. It was to find fault, fix responsibility, and impose consequences. To ask, was the delay caused by the arbitrator, by a recalcitrant party, and then to deter repeat behavior with fee cuts, cost, or substitution. But that hard work never happens. Instead, the court simply reset the clock. So Section 29A has become a rubber stamp, a deadline without teeth. Now, irony is that while anecdotes may suggest that arbitrations finish on time, litigants still pay the price. Extra filing, court costs, and wasted trips, while lawyers and arbitrators carry on without consequence. So the lesson is sharp. Clocks don't change behavior, consequences do. And without automatic low discretion sanctions, Section 29A remains a signal and not a constraint. Thank you.
Thank you, Prashant. This was an interesting take on Section 29A, and data throws light on how Section 29A has been interpreted and what impact it has had. And since this data, as I understand, is from the Delhi courts, courts across India must be scoring much lower than this. I would now like to go to my panel, Justice Bhat. Over to you, sir.
Good morning. Well, it's very awkward, so good noon to all of you. This topic which we are now debating, and my co-panelists, a very distinguished co-panelist who have experience not only in litigation, arbitration, as well as in the industry, I think it brings a lot of diversity and experience to the table. The topic seems very simple, which is Section 29A, the causes that led to its introduction, and how has it played out in the last, now we have this avatar for the last 6 years, the 2019. At the beginning, I must make a confession, which is that I was part of the committee, the Sri Krishna committee, which actually recommended the introduction of these time limits by the amendment which ultimately came in 2019. But then the data that today we are seeing and the way courts have interpreted this has actually was not actually visualized by the committee. The committee's concern was that the 1-year time limit imposed by the 2015 amendment was too limited. And therefore, in the recommendations of the committee, we took note of a lot of representations. We had broad consultations from stakeholders, lawyers, institutions, as well as academics and practitioners in the arbitration field. And based on those inputs, we said that it should be 1 year plus 6 months, and that 1 year to be reckoned from the date of the last pleading in the arbitration proceeding, with one extension. But astonishingly, it is played out in such a manner that we have 5, and then some of my panelists say it is 7 extensions to have been given, almost without a protest. Now, one need not emphasize or overemphasize on the need to have speedy arbitration. In fact, one of the main objectives of arbitration is not to replicate court proceedings, but access to justice in a class of cases where both parties agree to a neutral adjudicator in a timely and effective manner, and in an atmosphere where the procedures are actually agreed or consented to, and where you can expect an award or a decision at a fairly reasonable time. Now, if one looks at the history of time limits, it's a mixed thing, in the sense that there have been views on either side. But before that, let's just go through the bare text of the enactment. This section was introduced in 2015 and came into force on 23rd October. According to that section, the tribunal was to conclude the proceedings and pass its awards within a period of 12 months. This duration could be further extended by a period of 6 months upon consent by both parties. Upon cessation of 18 months, that is 6 months in addition to the 12 months, the mandate stood terminated unless extended by a civil court. And the original section introduced in 2015 also provisioned for the reduction in the fees of the tribunal. In 2019, pursuant to the recommendations of the committee, Section 29A was amended considerably. The amended Section 29A provides for completion of proceedings within 12 months from completion of pleadings. So naturally it gets extended to another by 6 months, the initial period. And thereafter, it is extendable for a further period of 6 months upon consent of parties. So which means that you have 24 months within your control, 16 months granted by law and 6 months with consent of parties. Now this is what was visualized. But then if you wanted a further extension, you went to the court. Now whether you could go to the court within the time or even after the lapse of time itself became a controversy. Ultimately, the Supreme Court settled it in the Berger Paints Rowan Builders dispute and said that you can go back to the court even after the lapse of the 18 months, after the lapse of the period agreed. Some of the challenges which we have come across, one comes across, is that the date of completion of 12 months after the completion of pleadings in cases where time was extended beyond the stipulated period of 6 months. Now we have 6 months. Now how do we deal with this timeline in very complex and voluminous matters? Here the period for completion of pleadings exceed the duration of 6 months. Section 29 states that commencement date for the purpose of calculating 12 months is the date on which pleadings are completed. Therefore, it remains unclear if 12 months are to be calculated from the completion of pleadings or after 6 months of completion of the pleadings. Now this, I don't know, I have not yet come across any judgment, but I am sure this will be one of the points which will be raised. I don't think this has been a major controversy, but going forward it could be. Then the biggest criticism to these time limits have been the erosion of party autonomy. Party autonomy is arguably the soul of arbitration. In the light of the principle of party autonomy, it is argued that parties should be free to decide on the timeline of the process they are willfully subscribing to. Possibly stringent timelines too, especially when all else is governed by the will of the parties, including the governing law, composition of the adjudicating body, and other procedures. Another concern is arbitration, being an alternative dispute resolution mechanism, aims to achieve minimal court intervention, with the provision in the Act that requires parties to seek extension from a court, even in the absence of any dissenting party. So this process of going to court itself adds one layer of delay. Of course, the study presented to us has given a very encouraging picture, but I suspect that's not the entire picture throughout the country. I'm sure that Section 29A applications themselves may take about 6 months, 3 to 6 months, maybe even a year to be disposed of. Then what happens to that layer of delay? No doubt Section 29A introduction is a laudatory step, and it has contributed in the expeditious disposal of arbitration proceedings. I think a similar study would be called for, where we'll actually look at awards that reach the court where there has been no extension. I'm sure we can extract that from the reported judgments under Section 34. So there is a fair bit of it in that catchment of samples. You have 100 or 200 cases, of which you find that maybe 60% are cases where there is no extension, or at the most the extension is with the consent of parties in the first 6 months. That is an overall limit of 24 months. I would say even a 50 to 60% strike rate is a very encouraging move. But the real problem, I suspect, is more. I think at the outset, what was outlined appears to be the reality, that the courts take a long time, and the courts are more than willing to give extension after extensions. But then, if we go to the other side of the story, where does it lead us? Now, in a given case, the court gets fed up and says that we are not going to extend. We have already granted you 2 extensions, so I will not grant you. Then where do the parties go? They are left to their devices. They're back to square one. Does a new arbitration commenced, obviously if either a new arbitration is commenced, or if both parties do not consent and one party goes to the court, where does it lead you to? So I think the solutions are not easy. We don't know if you say that there is no extension, or even if there is an extension. I have, at least in my limited experience as an arbitrator, I've come across cases where not extensions, where some parties do not agree to the continuation of the same arbitrator. They say, we don't want you, or the arbitrator ceases to act. I've got some of those cases, 3 or 4 of those cases. Then you're at a loss whether it is the mandate of the arbitrator which ended, or the parties, one or the other party says that, no, I'm not willing to continue with the same proceedings, so let us start afresh. This too happens. Now, there is no easy solution. There is no legal, we have not yet, one has not come across any solution to this or any way forward. In fact, I have been appointed by the Supreme Court in some of these cases where I'm a substitute arbitrator. Instead of a previous panel of 3, I'm now taking over a couple of cases where I'm the sole arbitrator. And it becomes hotly contested by the parties that this is a new arbitration, why should we proceed with that? Now, my point is, the whole idea of arbitration is that we should speed it up, so let's go ahead. Why should you file fresh pleadings and go into fresh evidence? I'm willing to take it over. But if the sense that I get is, much depends on the personality of the tribunal. If the arbitrator is able to persuade and convince the parties that whatever has occurred can be a part of the tribunal and they consent, you can continue with it. So that is where this party autonomy issue comes in to center stage. I will not go on further because we have a panel and I think we don't have too much time, except to conclude this with reference to the arbitration rules of various institutions. Now, we have time limits given in the ICC and some of the other institutions. 6 months' time is given to arbitrators to complete the proceedings after the pleadings are completed. And the recent amendments in the SIAC have differential proceedings where the entire proceedings can be ended in 3 months or in 6 months, depending on the monetary limit of the claims. Now, I think a push forward, in my view, towards institutional arbitration where parties are compelled to adhere to timelines and where tribunals also are strict about it, and most importantly, even the institutions maintain tabs on this and ensure that these timelines are adhered to, failing which the tribunals let's say, maintain different lists about arbitrators who are unable to conduct and conclude proceedings would be a way forward. And I would commend that even in the absence of amendments, our institutions should be strengthened and we should be more involved meaningfully to ensure that timely awards are given. Otherwise, the horrific specter of arbitrations going on for more than a decade will continue and that we will have no easy solution. Thank you.
Thank you, sir. Thank you so much for sharing your views. We'll now continue and go to the other panelists. I would first like to invite Mr. Rai to explain the interplay between Section 23 and 29A, specifically with regard to the timelines under Section 23 being directory.
Thanks, Kunal, and good afternoon, everybody. Just before I come directly to 23, maybe just to take off from where Justice Bhat was saying and from Trustbridge's research and its report, I found a very interesting opening sentence in one of the 29A judgments. And the judge writes, Ordinarily, petitions for extension of the mandate of arbitral tribunals are 2-minute affairs, where the court has only to examine when the mandate terminated and extend it as sought by the parties. Contest is rare in such cases. And I think that kind of summarizes what Trustbridge's results empirically show, and also perhaps shows that I think we need to look a little bit more closely at the reason for the introduction of 29A itself. And my thesis is that the 29A was inserted not as a check on parties necessarily, but as some level of minimal supervision of arbitral tribunals. And why do I say this? Because arbitral tribunals already have a whole host of provisions to ensure the speedy disposal of that arbitration. And Justice Bhat said it depends on the personality of the arbitrator. That is, of course, the largest part. An arbitrator can nudge the parties to ensure that the arbitration moves forward relatively quickly, as is the intent of the arbitration. But in addition to that, the Arbitration Act itself shows us that the arbitral tribunal has powers in the Act to ensure that parties are not able to delay proceedings. And I want to reference Section 24(1), the proviso, which requires the arbitral tribunal as far as possible to hold hearings on a day-to-day basis. I don't think we see that provision deployed or employed very often. And similarly, there is Section 25, which deals with default of a party. And again, if a party is delayed in filing its statement of claim, the arbitrator is empowered to dismiss the claim. If a party is delayed in filing its statement of defense, is entitled to dismiss that defense. So, if we understand it that way, that the arbitral tribunal has already got a lot of power and indeed the responsibility to decide every trial quickly, the real purpose of the 29A insertion was that in cases where the arbitral tribunal is able to explain why it needs more time, then that extension of time is to be given. It was not intended for the parties to delay proceedings and then be able to go to court and say, now the arbitral tribunal needs more time. I think the Justice Sri Krishna Committee report, of which Justice Bhat was a member, tried to address some of this, and the important changes made pursuant to that Justice Sri Krishna Committee report, although I'm not sure the legislation implemented faithfully what the report wanted, was that a period which was supposed to commence under 29A from the constitution of the tribunal became a period from the completion of pleadings. And completion of pleadings was ordinarily to be done under Section 23 within 6 months of the constitution of the tribunal. So the Justice Sri Krishna Committee report, as Justice Bhat said, felt 1 year based on stakeholder comments was too little. 1 year became 1 year plus 6 months for the completion of the pleadings. But the Justice Sri Krishna Committee also made a comment about excluding international commercial arbitration from the mandate of Section 29 capital A. And here I feel perhaps the exclusion should have been for institutional arbitration. Because international commercial arbitration could also be ad hoc arbitration. What really ought to have been done in my respectful submission was that 29A should have excluded institutional arbitration. But what has happened as a result of the legislative change in 2019, and this goes to Kunal's question about the interplay between 23 and 29A, was what was an inelastic period under 29A has now been preceded by an elastic period. That is to say, where we had a fixed time when the time clock started, now the time when the clock under 29A starts is when pleadings are complete. And pleadings itself has now been held not to be just the statement of claim, but also the statement of defense, of course, but also a rejoinder. I don't know what will happen when there is an amendment to pleadings and whether the clock will restart for the purposes of 29A. And similarly, the word pleadings in terms of statement of claim and defense perhaps doesn't do justice to the manner in which pleadings are sometimes done in arbitrations, for example, a memorial style pleading. So I think that we ought to have thought a little bit more about whether just SOC and defense is the pleadings we are referring to. And certainly that clock should have been a fixed clock, not a clock that is discretionary, and the pleadings can therefore get extended. That's as far as the interplay between 23 and 29A goes. I mean, like I said, I think an inelastic period has now become an elastic period plus thereafter the 29A period. And the other interesting question is, what is sufficient cause in 29A5 for extending the period of the arbitration? And here I'll make 3 quick points. One is sufficient cause cannot be the same sufficient cause that we understand for extending periods of limitation under Section 5 of the Limitation Act, or while filing an appeal against a 34 order, etc. Why do I say that? Because sufficient cause there is a party has been delayed in moving an appeal and seeks extension of that time. Here we are dealing with a very different situation where perhaps a party has been delaying in the arbitration and it is the other party that is asking for the extension of time. So the explanations that we've had from Section 5 perhaps are not of much help to us in the context of Section 29A capital 5. But obviously sufficient cause has to have some meaning. And the meaning given in various decisions is to have regard to the purpose of the provision, the purpose of 29A. But while saying so, I'm not sure we have really honed down on what that purpose is. For example, Hon'ble says that such extension is not granted mechanically on filing of the application. The judicial discretion of the court in terms of the enactment acts as a deterrent against a party abusing the process of law or espousing a frivolous or vexatious application. Delay even on the part of the arbitral tribunal is not countenanced. Hon'ble is actually speaking in 2 different voices in that sense. They're on the one hand saying that recalcitrant parties cannot be allowed to get away, but they're also then talking about delay on the part of the arbitral tribunal cannot be countenanced. And I think it's that latter that we really need to focus on when we're talking about sufficient cause. Because are we then saying that where arbitral tribunals are delaying, then there can be no automatic extension or there can be no extension? The challenge though comes, and again Justice Bhat alluded to this, what happens if you do not extend time? Because if you do not extend time, then the parties may have to go before a new tribunal or a new set of members. And there's another decision of the Supreme Court called Ajay Protec that says sufficient cause should be interpreted in the context of facilitating effective dispute resolution. And the question there is it effective dispute resolution in that case, or more generally to send a signal to the arbitrators that delay cannot be countenanced? I think the best way to address this actually is maybe 2 things I would suggest for the legislature. One is, or even for the court to pass as a general order, that arbitrators should at the very outset of the arbitration set out a procedural timeline. If it's a complex matter that does indeed require more than a year or even a year and a half, that procedural timeline at the very inception of the arbitration can state what that timeline is. Because against that you can measure whether the tribunal is acting promptly or not. And the second thing is that when 29A applications are moved, there should be a little greater onus on the arbitral tribunal to explain why that application is meritorious. That is to say, perhaps a procedural order by the tribunal indicating how it has acted and why still some extension is to be granted. Because otherwise, my view is 29A has certainly acted as a soft push towards the arbitration ecosystem, because no arbitral tribunal also likes to be subject matter of a 29A application. But if it is to be something more than a soft push, we perhaps need some more legislative teeth to this provision. That's what I would say. Thanks.
Thank you. Thank you so much, Mr. Rai. I would now request Mr. Jalundhwala to also share his views and supplement what Ritin has just said.
Thank you. Good afternoon to all. This interplay between section 23 and 29 is very important. If you see, there is a vast difference between these 2 as far as the limit is concerned. In the first, it is said okay, within 6 months of the appointment of the arbitrator or the panel of arbitrators, you must complete the pleading. And that particular sections is not mandatory. It is directory. If you now go to 29A, which clearly says that the arbitration has to be completed within 12 months, and that is from the completion of the pleading. So there is a difference between these two. One 6 months from the date of appointment of arbitrator, and here 12 months from the date of the completion of the pleading. So no blame game can be assigned to the arbitrators because pleadings are completed, then their work starts to complete this arbitration within 12 months. Now, there is a question mark. When to be considered pleadings are completed? Ritin ji has rightly said, okay, pleadings to be completed not only claim and counterclaim or defense statement, but when the parties are allowed for filing rejoinder, sur-rejoinder, all this has to be considered as the pleadings. And therefore, the pleading will be considered as completed when all these sur-rejoinder, rejoinder have been filed as allowed by the arbitrator. And from that day, the 12 months starts for the particular arbitration to be completed. There are various judgments on this. Some of the judgments, one says, as far as buoyant technology, Karnataka High Court decided that the pleadings shall be considered as rejoinder, sur-rejoinder, everything. When it is completed, then it is called as pleading completed, and the actual period should start accordingly. The same matter went to the Supreme Court, and the Supreme Court also affirmed the views of Karnataka High Court, and which is a correct stand because anybody is allowed to file the rejoinder, sur-rejoinder, then for the clock starts from that day. So this is what about 29, and it is a very, Bhat Sahab was the part of the committee members, 29A, that has come in 2019, which is a valid, I think, appreciable amendment as far as the Indian arbitration is concerned, because there is some limit which has been put into to complete the arbitration. Now, I'm just going to the sufficient cause. There is still a lacuna in this legislation. There is no word, nothing mentioned about what should be considered as the sufficient cause. I think it leaves to the court that they should decide that which can be considered as a sufficient clause. Like in force majeure, we can say a force majeure includes so and so, but it is nothing that. But for the sufficient cause, as a corporate, what we are doing, when the arbitration starts, we should record everything when pleading started, when the other side asked for the time, when I asked for the time, how much time has been taken for the cross-examination of the people. Sometimes I feel I will take the witness examination in 3 days, but it went for 6 days or so. In such situation, all these dates and other things have to be recorded by us. And when at a particular time where I have to make an application for the extension, then at that time I can demonstrate this is the sufficient cause and which is beyond my control. Beyond my control covers two things, one natural and second is non-natural. And if you see natural means when COVID situation was there, even though at that time some cases has happened and where the court has said okay, there is a sufficient cause for the extension of this particular arbitration. So the sufficient cause means no frivolous ground, no baseless ground, and that should be completely on a concrete our justification that this needs to be extended. Now, in this sufficient cause, I feel that whenever we are making an application for extension, it is desirable to make the application before the arbitration period is over. So the court will definitely take up in a bona fide way that they have come before the arbitration 12 months period is over. That should be there and have to put in record the various parameters why I am coming for the extension of the time limit. In one of our cases, we have to go for 4 such extensions, and it was fortunate that both the parties put together go for extension. But at the fourth extension, High Court said, okay, now I am giving this is as the last extension, and you have to finish that the arbitration by that time. So these are my thoughts on sufficient clause and interpretation.
Thank you, sir. Thank you so much for your views. It's always interesting to hear the in-house counsel views because they explain the difficulties in the best possible manner. I would now like to go to Mr. Thakore. So the question is, what are the practical implications of the legislature not prescribing a maximum duration on extensions granted or the number of extensions permissible under the provision? This is being highlighted as a serious lacuna. You would want to hear your views, sir.
Before I go to, am I audible? Yes. Before I go to this, my personal view is that 23(4) is sacrosanct and there is no discretion. In fact, the suggestion of the committee was to use the word may. The legislature instead has used the word shall. And if you see 23(4), the language, it is not completion of pleadings. It is statement of claim and defense under this section shall be completed within a period of 6 months. So it's only the statement of claim and defense. At the highest, it can be if the defense has a counterclaim, it can be a statement of defense of the counterclaim. So all those pleadings have to be over within 6 months, and this cannot be extended. I am aware that the Calcutta High Court has taken the view that it is discretionary, but recently I have come to know that Delhi High Court has taken the view that this is mandatory. My personal view is that it is mandatory. If it is mandatory, the period given is 1.5 years, plus extension with consent of 6 months. So that will be a period of 2 years. And pleadings have to be completed, even if it's a detailed matter. When you approach when you apply for arbitration or issue a notice of arbitration, you are aware what you are going to plead. So the question of not being able to prepare the complete pleadings within 6 months is unpardonable. That is my first issue. Going there, the role of arbitrator to see that the proceedings are completed within a stipulated time is very vital. And being on the lawyer side of arbitration, I find that a lot of arbitrators are not laying down the procedural requirements from day one. If all the procedural requirements, I have seen some arbitrators doing it. And late Justice Lahoti used to do it on the very first day of the hearing, where he would lay down the date of witness statements to be filed and cross-examination to commence on certain dates. Everything was laid down. Now, if that is laid down, the comparative table can be created how the arbitration has proceeded and where is the fault when you go for sufficient cause before the court. Now, as far as the question posed to me is concerned, I am of the view that there cannot be a limitation on extensions. It has to be left to the court. The very purpose of leaving it to the court is to see that court will decide on the limits, number of extensions or the period of extension. There is some third party, some judicial forum which decides that. To impose a condition that it should be only limited to 1 extension or 2 extensions can be disastrous. It will lead to further delay because the arbitral tribunal will collapse and new arbitral tribunal will come into existence. And I am facing one arbitration which was started in 2017. I am at the stage of final arguments in 2025. The reason was one arbitrator died, another arbitrator resigned, third arbitrator who was appointed withdrew, and now the new arbitrator is appointed. The resultant effect is that 7 years have elapsed. Originally, before the first arbitrator died, already the arguments were over. It was for award, and I am told that the award was ready, and he died. Now, this resulted in 4 years delay. So how do not seek extension? Extension has to be sufficient cause for extension. So it depends on facts of each case. Therefore, there can never be a limit that it can only be 3 extensions or 2 extensions. That's the only thing. Open to any question.
Can I go to now Rashna for her views on this question?
Thanks. So, friends, my co panelists have already stolen the thunder. They've explained to you all the orders, all the sections, all the precedents, section 29, 23. Now, I'm left with giving you my thoughts or what the clients or the litigants in an arbitration go through. So you heard why 29A was inserted. It was inserted so that timely completion of arbitration happens. Then India comes up to the international standards, and the costs also come down of litigation. So there's not an endless period of litigation. Now the creature of extension came in, where parties know we can extend the arbitration. It is not limited to 12, 6, after that 18 months also we can mutually go and seek an extension from the court. Now let me come back to the conduct of the parties. We parties are equally or more to blame. We know we're going to get extension. We know I just don't want to put in my good points. If I have 10 points, good, bad, ugly, just throw everything, throw the whole lot. You never know which one sticks. So I do that. Now my person who has to respond says, "Arey, usne to 10 dala, let us answer his 10 and put my 10. So imagine the poor arbitral tribunal. I'm throwing evidence, I'm throwing expert opinion, quantum, analysis, delay, EOT, everything under the sun, plus other witness, my witness, his witness. It's voluminous. And I'm talking from the infrastructure companies where already the projects take 10, 15 or not, or maybe more to complete. So imagine the volume of paper or the volume of evidence, the volume of data that I throw out to the poor tribunal. I mean, I sometimes pity the tribunal. It is easy to blame them for delay, but we are equally to blame because we know that there is extension. Now, when big I'm just taking my example, if there are big infrastructure projects where millions, billions is involved, I don't want to circumvent any arguments. Take every point and elaborate and make sure I've covered everything. So after the brilliant conduct of the parties, now the poor tribunal has to sift through all the data. They have to say which is the good, bad, ugly, and decide on the award. Now, I expect them to finish in 6 months. Is that fair? No. They also need time, depending on the amount of volume that I've thrown across to them. Then parties go and seek extension. I have, in my experience, not come across a single matter in court where the court has asked why you've come. It's simply extend. Whatever we've asked for 1 year or 6 months, or if the tribunal has asked for a 6 months extension, I've easily got it. I've got no problem. Now the creature of the section which says that the court will penalize the arbitral tribunal for delay. You think I'm going to blame the arbitral tribunal even if it is their delay? Absolutely not. I mean, which party is going to go and say that that tribunal of mine is a problem? Arey, mera award will go against. So we all have to be respectful. We all have to understand and not blame the tribunal. So the section which has been inserted was inserted with a proper thinking of the legislature, but in reality, it doesn't work. No party is going to blame the arbitral tribunal. Leave alone the court investigating suo moto, trying to find out whether my justice brother X has delayed. Oh, he delayed. Okay, I'm going to levy a penalty. Fine. Minus his fees by 5% per month of delay. Unheard of. And no judge will do that to his brother judge. I'm sorry. So this section also falls. It's good on paper, but reality sucks. Also, I heard my friend Prashant giving all the statistics, which is, I think is right. I have in some matters sought 4 or 5 extensions. Arbitration takes place for around 4 or 5 years, then another year and a half for the award. Then the creature of 34 EPs, I mean, that, just forget about it. But to end with, I would say the Delhi High Court has been very supportive to arbitration in every set 34 and EPs. They are getting the amounts deposited, and the party who has the award can withdraw the money. So in that way, I will say that the Delhi High Court has been very supportive. Now I will stop there and thank you.
Thank you. Thank you, Rashna, for your views. Going back to Mihir bhai. Mihir bhai, what are the challenges in imposing reduction in fees or substitution of an arbitrator for inordinate delay attributable to the tribunal?
The first challenge will be to what extent you can blame the tribunal. Sorry. The first challenge will be to what extent you can blame the tribunal. If one party is delaying and the tribunal is allowing the party to delay the proceedings, you can blame the tribunal. Otherwise, you can't blame the tribunal. Secondly, assuming you can blame the tribunal, which party is going to dare blame the tribunal if they want to see that the same tribunal functions? So the reduction of fees is almost an impossibility to achieve. Third, assuming the court passes the order of reduction, there is all possibility that the tribunal will resign, in which case a new tribunal will have to be constituted. There is no compulsion that the tribunal will function at a lower fees. So these are the limitations in respect of reduction of fees. In respect of substitution, it's a different thing. If you can make allegations not only of delay, but some other delay which clearly indicates the tribunal is favoring a party to see that the proceedings do not proceed, then certainly the court can substitute the arbitral tribunal. But then the burden will be very heavy to prove that the arbitral tribunal is itself delaying the proceedings in that sense.
Could it be a consideration for the court that the arbitrator is taking up more than a particular number of arbitrations? Could this be taken into consideration?
The factual position is that whenever I am sitting in a when I am arguing in a 3-member arbitral tribunal, the fixing of dates is an impossibility, because each of the members of the arbitral tribunal has a fixed calendar where they are appearing before heading some other arbitral tribunal. Therefore, effectively, the delay is caused because of overburden of sole arbitrator. The dates are much easier and the matter can proceed much faster. But with a 3-member arbitral tribunal, it's impossible. And delay is because of multiple arbitrations being taken up by arbitrators.
May I now go to Justice
I
Bhat
believe
on
that
this?
an arbitrator should not take more than 2 arbitrations in a year.
Kunal, if I can just add to that, I think Rashna has very well expressed the human issues that are involved. I mean, there's a client who wants an award from a tribunal. It's almost impossible for the client to take a particular position qua the tribunal. But just to answer your question, there is also Section 12 in the Act, which is that the arbitrator at the outset has to express his or her confidence that she can complete the arbitration within a period of 12 months. Now, again, that's the... Sorry?
That is mechanically given.
And yeah, I think the answer, therefore, is when we try and think about what the statute says versus what a litigant faces, the answer is clear. There has to be someone else objectively who can look at what the tribunal is doing. I think what this discussion is showing us is that it can't be the court. And I think, therefore, the only other way forward, and it's not because this is an MCIA arbitration, is for an institution. See, 29A has worked to some extent, at least at the back of our minds, or at least at the back of arbitral tribunals' minds, is let's try and be expeditious because we don't want to be subject matter of an application. And, as lawyers also, when we appear in court, we're very careful not to say who the tribunal is. The judge doesn't ask. There's, of course, confidentiality, but sometimes the tribunal's members' names come in an order. They don't like that, and for a good reason. But that reputational issue, I think, can best be addressed in institutional arbitration, where if an institution, it can nudge arbitrators to be more expeditious. As Justice Bhat said, the rules themselves have sometimes time limits. But the second issue is that even if in that particular matter a tribunal hasn't been expeditious, it affects them in future appointments. And that itself acts as a check on how to do it. So I think where this discussion is converging is that 29A can only be a soft nudge, but maybe institutional arbitration is actually the way forward for expeditious arbitrations.
Justice Bhat now, please, sir.
Institutional arbitration is the problem is that most of the arbitration agreements do not contain a clause of institutional arbitration. Therefore, how do the parties go to institutional arbitration? Second problem is that when there are disputes which relate to individuals or partnership firms, the question of going to institutional arbitration does not arise. It remains within party-nominated arbitration.
Yes. Now, I totally agree with Mihir Bhai about the fixing of dates and calendars of arbitrators, but then I don't think we can fix this issue by saying that only X or Y or Z is at fault. Because even in three-member tribunals, we see that most of the practice is, if I'm sorry to use the expression, one of the mandates of the 2019 amendment, which the committee of the Sri Krishna committee was to improve the status and bring about a robust arbitration bar. Unfortunately, that kind of bar has not developed where you have full-time arbitrators and full-time practitioners, which results in various distortions. As an arbitrator, I can say this, that at least in my experience, more than half of the final hearings or even cross-examinations we have to resort to in the evenings. If I am given the choice, I would, and I do, in some of the cases I do insist, because if you are able to schedule the hearing well in advance, you have a full day hearing from 10:30 to 4, and you can wrap up the cross-examination and final hearing. So in three-member tribunals, when you have this kind of part-time phenomena, it's not just 3, you have 5, and perhaps 7 actors. So which means you have a senior counsel, you have a firm behind him, and vice versa, and 3 arbitrators. So the puzzles get more complex to fit. As far as institutions is concerned, I tend to agree with Ritin that the accountability can be through institutions. In fact, I would say that this was one of the main objectives of the committee's reports, to strengthen and push parties towards mediation, towards institutional arbitrations. I don't agree with Mihir Bhai that it can be, even in individual cases, it can't be. I mean, I'm seeing the Delhi High Court, the Delhi International Arbitration, which I was one of the founders and I chaired for 3 years. All the 11s, wherever there is a controversy, invariably, even in individual disputes, the arbitrations do go there. And I'm glad to say that a lot of young lawyers are arbitrating now and acting as arbitrators. And invariably in that center, as well as in some of the international centers like ICC and SIAC, a declaration is sought as to the number of arbitrations which the nominee is actually has got in hand. So that's a way of controlling it and ensuring that there is timeliness. And I strongly believe that institutional arbitration is the way forward. I'm not saying it should be compelled, but I think if we build robust institutions, and I don't think we have to look at the government alone. We have robust and very prosperous law firms. We have industry. What prevents them to get together and create an institution, a robust institution run by credible professionals? Now, if you do that, then you don't have to depend on 1 or 2 institutions. And there are government-run institutions have their own limitations. They are not able to market it. There are budget constraints. Whereas in the case of these kind of private institutions, those constraints and barriers are not there. But then that's all in the future. We are looking at 29A. Thank you.
Thank you, sir. Thank you so much. I am sure Neeti is smiling somewhere. The last question to the 2 general counsels, Jatin Bhai and Rashna. Are parties left with any choice but to extend the mandate for 6 months under 29A3? And is there any party autonomy there?
Absolutely, yeah. I mean, both parties know that we are never going to finish in 12. It has to be extended mutually by 6. It's a taken thing for me, at least. in my arbitration. And generally, parties do agree. So there is no dispute that I have come across.
If you want to deny someone an extension, would you dare a denial? That's the question.
I have personally not come across any such denials because what happens is the party who's instituted the arbitration will restart another one, so you're back in the same position. But personally, I haven't come across, so parties do mutually agree.
Jatin bhai.
Yeah, this party autonomy versus 23A4, 5 and thus. The 29A3, which gives autonomy to both the parties, that both the parties mutually can agree for 6 months extension. But sometimes it is very difficult to get the consent from the other side. Let me tell you sometimes what happened, we have a PSU, or government organization against us. So they themselves may not would like to give consent. And they may say, you take it from the court. Because they don't want to put on the record that they have given the consent for the extension of the arbitration. Secondly, this autonomy is only in one subsection. And thereafter, it is essential for the court to interfere and to give its judgment, yes, this is being extended for further 6 months or so. And there are a number of cases. One of the cases happened in L&T in Delhi High Court, where the liquidator was appointed and the arbitration was between L&T and that liquidator. The liquidator did not give the consent. And the L&T has to approach to High Court and shown the reasons why I need the extension. Finally, Delhi High Court gave the extension. So there are a number of cases happened, even number of cases have been, I think, recorded in various high courts about this extension. And that clearly says that both the parties do not agree with each other for the extension. In recent judgment, it's a little bit different. On 1st September in Delhi High Court, one judgment has been given. What it says, there were a number of extensions given in the arbitration. And after that, because the award was not prepared, and once after say 12 months or so, the award was announced. The other side challenged the same in section 34. And the judge gave the judgment that this limitation or beyond a particular period, if the award is given, it is against the public policy. And therefore, the award was set aside. So how ridiculous, on one side, the same high court, maybe different judge, giving 3-4 extensions, and thereafter the award is set aside. So this is happening, and if this 1st September, if you have seen this announcement of the judgment. So this consent of the parties, even though autonomy we are putting, but I don't think it is independent and both the parties can agree to the mutually to go for the extension, except one or so. Otherwise, there will be always a case in the court and get it decided.
Contract.
Yeah, you are right.
Put it down in the contract.
Thank you so much for your views, sir. Are there any questions from the audience now? Yes, please. On the first table, please.
Just wanted to share my view. I feel today 29A1 has no meaning because there's no hard stop under 23.4. Parties can take years to file their pleadings. There's no remedy under law right now to stop that. So of course, I echo with Ritin, institutional arbitration is the only way that we can see, because even institutes won't allow you to take years and over 6 months to file your pleadings. So I don't know how this is acceptable. So even the TK Vishwanathan committee report of 2024 recommended an amendment to 23.4, making it mandatory, the 6 months time period to complete the pleadings. But unfortunately, there's no mention of it later in the subsequent bill that was passed. So I think this is a change that we really need to actually make 29A1 effective.
Hi. So my question is with respect to 23, section 23. If I read the section 23(1), it's actually starts with within the period of time agreed upon by the parties or determined by the arbitral tribunal, right? There they say that the claimant shall file everything that's they want to plead with, with the consent of the parties or how the tribunal prescribes it. Now, I have seen certain cases where the tribunal, even if they directly put the parties into the bracket of 6 months to complete the pleadings, the parties themselves comes up and says that, sir, 2 months' time is not enough for filing of the statement of claim, or when the statement of claim is not filed within that 2 months period, even if it is granted, they seek another 4 weeks to file the same. And this has happened a lot with the PSUs where they do take almost 6 months to file their statement of claim. So Mihir sir, when you say that this is a mandatory provision, 23(4), how will that work as a mandatory provision here? When the section starts with unless agreed by the parties or granted by the
Can we
tribunal.
read both the sections together, 1 and 4?
Yes, sir.
Within the period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state facts supporting the claim, the points at issue, and the relief of remedy sought, and the respondent shall state his defense in respect of this particulars unless the parties have otherwise agreed as to the required elements of those statements. Now, this time agreed has to be controlled by subsection 4. The statement of claim and defense under this section shall be completed within the period of 6 months from the date the arbitrator or all the arbitrators, as the case may be, received notice in writing of appointment.
But if the parties themselves come up and say that we can't complete within 6 months,
then the consequences of 25 will follow. Should follow. And now I believe Delhi High Court has taken the view that this is mandatory, contrary to the earlier view of Calcutta High Court. That is in 2023 SCC Online Delhi 520. It has taken the view that this is a mandatory provision. And if the mandatory provision, the claim statement is not filed, then section 25 should follow and the arbitrator has to terminate the proceedings.
but there are cases where, sir, there are sufficient causes which are shown by the
The
parties.
question of sufficient cause doesn't arise if it's a statutory limitation period.
Thank you, sir.
Section 25 will be applicable only when the SOD is not filed. What if, no, the pleading? Sorry.
25B is dealing with the statement of defense, and then it says the tribunal will have the discretion to treat the right of the respondent. Yeah. A is statement of claim, the mandate is terminated. B is statement of defense.
My question is to Justice Bhat. While enactment of the Section 29A, was there any criteria to keep a limit on the filing of Section 29A5 application? Because it so happens that there was a matter in which an application was filed one and a half years later to the after the mandate had expired. So should there be a time limit to filing an application under 29A5 after the mandate has expired?
I think the absence of limitation indicates that there is no limit, but then I would not really go for that, because the general, I think Section 29 of the Limitation Act ought to apply, which means that the outer limit ought to be 3 years. Because Section 29 of the Limitation Act begins with the term, with the expression, I think it's something to the effect that if there is any, unless a contrary intention appears.
Sir, I understand, but if we were to apply 3 years, then the whole point of an alternate dispute resolution.
Yeah, but
with
then
the time,
are we allowing the states to, the courts to draw the line? The problem with the courts being allowed to draw the line means that you have often arbitrary red lines. What is reasonable under these circumstances? yes, one could argue that the overall limit being where parties can consent is being 2 years. Reasonable time would be 1 year. But on the contrary, there could be some people who say that there is no time limit. So one has to resolve. I mean, each area could be a thorny area for conflict and litigation. So I think I would not hazard a guess on this.
Thank you.
Thank you. Thank you so much. So just the last question. We are anyway out of time.
I'm Vikas Goel. I'm from Singhani and Partner. My observation is that this time period may be mandatory 6 months, but we have to see actually what is going to be the consequence. Is it that the time to file the reply or statement of claim will be closed mandatorily, or the time which is consumed in that will be taken from the 12 months period and 6 months periods thereafter? So in my understanding, it is not that once you are not able to complete the pleading within 6 months, then everything goes. But 6 months will stop there. And then the 1 year period would start.
Thank you, sir. Thank you for your views.
You use the statement of claim and defense under this section shall be completed. And section 25 says the claimant fails to
Shall
communicate.
terminate.
So, but sir, I just want to understand because, if we say that after 6 months you cannot even file, even if when the tribunal is willing to give that time and the other party has no objection. So 6 months definitely should expire. But to say that everything will go may not be correct. This is what my understanding is.
The trial will never begin. Then what time the trial should start? Timetable has to be there to see that even extensions of a sufficient clause, this timetable has to be maintained at some point of time.
Sorry, I'll just pass a comment. I think 23 Calcutta matter, we were the attorneys. I'm Nusrat Hassan, managing partner of Denton's Link Legal. So interestingly, we had a strong argument that it is mandatory in nature. So I kind of echo what you're saying, Mr. Thakore. Because ultimately the 29A, even if you look at the historically, the idea is to close the arbitration. 6 months came by a specific amendment. I think the intention of the legislature was never to make it directory in nature. That was our really strong, I'm really happy that Delhi High Court has made it mandatory. And we argued that at great lengths at the Calcutta High Court. But unfortunately, but I think the basic point for all of us as arbitration practitioners is ultimately the amendment of 15 has improved arbitration. If we change the timelines anymore, it is going to drastically affect the end user's satisfaction of this process. I think we have the GCs, and that's really going to be the critical understanding of arbitration practitioners. We feel, for arbitration practitioners, we feel very deeply about this process. So I think I echo what you're saying, Mr. Thakore, more than anything else. Thank you.
Thank you. Thank you. No, we're seriously out of time.
So going on 23's interpretation, it's only the statement of defense and statement of claim which are included. Recently, in 2024, there's a single judge bench judgment of Delhi High Court, and has also been done by Supreme Court in a matter that rejoinders have also now been included. And the MCO limited judgment of Delhi High Court specifically says that the 6 month period will expire and the 1 year period will only start, the 1 year period will only start once the rejoinder is filed. So isn't now this against the statutory scheme? And actually, because it's supported by both Supreme Court and Delhi High Court, it becomes a practice everywhere. Because there's a confusion.
What is it?
Language is not pleading. Language of 23(4) is confined only to statement of claim and defense.
That's probably the correct interpretation.
And
the High
therefore,
Court has taken a
no,
view
and
that
I
it
don't
should
say that a counter claim is not a, it's a pleading.
It is.
So the statement of defense of a counter claim, which may be a rejoinder in that sense, may be covered, but nothing beyond that. No, and further in a trial, why should there be any rejoinder? Arbitral tribunal itself should say that there should be no further pleading.
The trouble with the Calcutta and the Delhi view is they say that 29A doesn't say pleadings in terms of 23.4. So it's not linked to pleadings. So it can be any pleadings even if it's outside what is mentioned in 23.4. So now that takes very long. It says, but they said, but the judgment says there's no reference to 23.4.
This
In fact,
point,
yes.
this Karnataka High Court, what you are saying, it has decided the same thing.
Yes.
Okay, whether this rejoinder surrender includes or excludes, then they have said okay, it should be included. And the same view has been taken by the Supreme Court in the same judgment. And therefore, yes.
Yes.
And what they have said, okay, it is clarified that if the surrender to a counterclaim reply is allowed, it forms part of the pleadings which are deemed complete upon its filing.
So that's the
So
real
it is,
problem.
if it is allowed, that's the only point.
In fact, the Calcutta High Court has a language. It's very interesting. It says in a 29A, we don't want to be sitting with a whacking stick and a calculator. So we'll consider all the pleadings and not just the...
What happens when the tribunal permits amendment to pleadings?
My view is that amendment to pleadings is part of trial, and that will not, the period will start after 6 months. That's all.
Timelines remain unaltered.
Thank you so much, MCIA, for having us. Thank you, my Lord Justice Bhat, Mr. Rai, Rashna, Mihir bhai, Jatin bhai, everyone, for being on our panel. It was a great session indeed. Thank you for having us again. Thanks.